You're listening to Agriculture Today, and welcome back as we chat once again with Roger McEowen, Professor of Agricultural Law and Taxation, Washburn University School of Law. This time around, Roger takes up a subject which relates to just about any and every farmer and rancher in the interest of their privacy and protection against illegal search and seizure. The question is, how much agricultural property, Roger, is protected from warrantless searches? And this ties back to rights granted under the Fourth Amendment of the Constitution.
Well, it does. The Fourth Amendment does protect against illegal searches and seizures, and in general what that means is that the government has to go get a search warrant, and any agent acting on behalf of the government has to get a search warrant based on probable cause before they search an area unless the owner gives consent to the search. And so you're right, the genesis of all this goes back into the Fourth Amendment, which obviously is one of the first 10 amendments, which means it is a fundamental constitutional right to be secure in your, as the Supreme Court has said, and as the Constitution says, in your persons, houses, papers, and effects. But
that is subject to some interpretation here, and it doesn't extend into infinity, so to say, right?
Yeah, that's where the rub is, and that is exactly correct, because houses or your residence, yeah, you're secure in that. And there's a good body of case law that certainly explains your home is your castle. The government has to have a search warrant before they can enter your home and other personal items. But a lot of farming activity, hunting activity, recreational activity, and other things happen on farm and ranch land that's nowhere remotely close to the house. So are you secure in your farm and ranch land that's not immediately surrounding the residence?
And the term that's used here to define that surrounding area associated with your residence is curtilage. Explain what that is, if you would, Roger.
That's just a fancy-dancy legal term that the Supreme Court cooked up in 1924 to make it sound like we lawyers know what we're talking about. But that's a term used to describe the immediately surrounding area around the residence of the suspect in this instance. So if we think of that in an ag setting, can it apply to buildings and structures in the barnyard, garages? And the answer is, well, if they're used along with the residence, the answer is yes. And then you kind of get into that gray area. Well, it's farm equipment, it's livestock, that's not really used with the residence, so can that be searched without a warrant? And then you get beyond that, you get into fields and other areas, fields and forests and lanes and so forth. That's governed under what's known as the open fields doctrine, and clearly the government, according to the Supreme Court, does not need a warrant to search those areas, even if your land is posted no trespassing.
This has been the open fields doctrine, as you call it, explored through several prominent cases over the years and has been upheld as exempt from the warrantless search provisions that we're talking about here. Yeah, and again, there have been some cases where areas outside the residence, arguably used as farmland, has been held to be within the curtilage, which is meaning the government has to have a warrant. And, we start with a Washington case, a state of Washington case back in 2012, and there was an open clearing near a rural home that separated the home and outbuildings from a wooded area, and that was deemed to be curtilage. And so the court said, well, that area is actually suitable for use with the home, and therefore you have to have a warrant to search that, the government does, because it's closely associated with the home. But then you get beyond that. Another case out of Texas, a sheriff entered a pasture without a warrant, seized cattle, charged the owner with cruelty to animals, and the warrantless search was challenged, but it was upheld under the open fields doctrine. Another case out of Indiana, and this was a charge of cruelty to animals, cruelty to a dog. Police searched, didn't have a warrant, searched the home. Now the dog house was within the curtilage of the home, but the court said he had no expectation of privacy because, then this was the key, the dog was visible from the route any visitors to the property would be expected to use. Now, that's not typically the biggest issue for farmers and ranchers. The big issue is, what if I have somebody, let's say from the State Department of Wildlife and Parks or whatever it's called in a particular state, that comes across a fence, maybe a couple of fences, a couple of gates, it's all posted no trespassing, gets to the interior of my property, which say, the quarter mile, half mile inside the border,
and attaches trail cams to trees to watch what I'm doing on the interior of my property.
Actually,
so they have to have a warrant to have that.
That's the core of a case that was fairly recently decided in Tennessee, you say, Roger.
Yeah, indeed, that's exactly what happened. The landowner gets up early one morning before daybreak, gets in his pickup truck, and is driving down some of the interior lanes on his farm. He's going to go duck hunting on his property. And he rounds a corner, and his pickup lights catch a reflection up in a tree, so he stops, and that's out of the ordinary. So he investigates that with a flashlight and sees a trail cam zip-tied to trees. It's got an antenna on it, a transmitter on it. It's got photo storage. It has a SIM card. So he takes it down and takes it back to the house after he finishes duck hunting, and notices that thing's been up there for several months. It has thousands of photos of he and his family on it. It has some pictures of a couple of government officials on it, so that's how he identifies whose camera it is. And then he's sitting in his home one day, and government officials storm the house with guns drawn to get their camera back. So it kind of rattles the entire family, and he ends up suing them and said, "You did all this without a warrant. You trespassed onto my property. You crossed a couple of fences, a couple of gates. It's all posted, no trespassing. I obviously have an expectation of privacy if I'm posting those signs. You didn't get a warrant. You don't have any probable cause." And he sought to have them prosecuted.
Wow. As it wound through, it turned out that the open fields doctrine did apply here, and that the federal officials here were exonerated, basically.
Yeah, they were, and that's exactly what happened here. And this is the federal trial court in Tennessee, and they looked at federal cases that held that the use of cameras by federal and state game officials to monitor private property does not violate the constitutional rights of the property owner.
That should catch folks' attention right there as far as what the open fields doctrine allows. States individually can create their own legislation to address the situation, and you say that there's a new Kansas law fresh out of the State House that attempts to provide greater protection from warrantless searches on behalf of landowners. Talk about that, if you would.
Yeah, some state constitutions do protect the privacy of open fields, just like a private dwelling. So they just say that open farmland, ranch land, we're going to treat that as a private dwelling, as the residence. And so that makes it pretty clear that the government has to have a search warrant when they come onto private property. Now, other states have also tried to do the same thing. And as you mentioned, there is a new Kansas law on this. It's not in effect yet. It was signed into law on April 18, so just a few days ago, but it will become effective July 1 in the state of Kansas. And it's specific to the Kansas Department of Wildlife and Parks. So it bars any employee of the Kansas Department of Wildlife and Parks from conducting unauthorized surveillance, and that's the key term here, on private property unless they get a warrant or a court order or a subpoena. Now, given that language, that's fine. If they stop right there, that's fine. It just says you can't unauthorized surveil someone without a warrant. Surveillance is defined as installation, and I'm quoting from the legislation, installation and use of electronic equipment or devices on private property, including but not limited to the installation and use of a tracking device, video camera, or audio recording device to monitor activity or collect information related to the enforcement of the laws of the state of Kansas, end quote. Okay, that would have been fine had they stopped there. They did not stop there. They went on to say, quote, unless also authorized pursuant to the Constitution of the United States, end quote. Well, what did we just talk about? The Constitution has been construed to allow warrantless searches in open fields and areas other than those areas immediately surrounding the home. They just wiped out the entire effect of what they were trying to do, at least in my view. I suspect that this law is challenged, and this language remains the way it is right now. It gets challenged. Some court will knock it out saying, well, that was a constitutional search given all this body of case law that's out there. I'm not sure what this does by putting that exception in there.
In the meantime, farmers and ranchers need to be astute to what the law says about this. One would think that a no trespassing sign would handle all of this efficiently, but that's not necessarily the case here, Roger, it appears.
No, that's not the case at all. We've got a pretty good body of case law, unfortunately, from a landowner's perspective, that says that trespassing is not related to and not governed by the warrantless search provision of the Fourth Amendment. It's a separate issue. And so you can't just claim, well, you were trespassing to get access to put your cameras up on my trees. No, that doesn't matter. That's a hard one for people to understand, but they separate those two out. That's not a warrantless search issue. That's a separate trespass issue.
Roger has pulled together a really good article on this topic in his blog series. It's fresh out. It's entitled Curtilage, How Much Ag Property is Protected from a Warrantless Search. You can find that at washburnlaw.edu/WALTR. And 2 weeks from now, we'll visit again. Roger, until then, many thanks.
Thank you, Eric.
He's Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. We'll return on Agriculture Today.